Hearing will resume.
Sure.
The first witness on our next panel, panel 5, is Mr. Fred Gray, senior partner at Gray, Langford, Sapp, McCowan, Gray, and Nathanson, veteran civil rights attorney with an extraordinary record of representation. At the age of 24, he represented Ms. Rosa Parks, who involved in the historic refusal to give up her seat on the bus to a white man, is so well known. That action initiated the Montgomery bus boycott. He was Dr. Martin Luther King Jr.'s first civil rights lawyer. In 2004, Mr. Gray received the ABA Thurgood Marshall Award for his contributions to civil rights. Graduate of Nashville Christian Institute, Alabama State University, and Case Western Reserve. Thank you for joining us, Mr. Gray. I haven't had an indication from Senator Leahy about whom they'd like extra time to, but my sense is that you'd be on the list, so we're going to set the clock at 10 minutes for you. You may proceed.
Thank you very much, Mr. Chairman.
By way of explanation, the judges talked longer yesterday, and I thought it appropriate not to interrupt them and want to give the extra time to this panel. And if Senator Leahy comes in and cuts you off, Mr. Gray, just remember I gave you 10 minutes.
Thank you very much, Mr. Chairman. And to my senator, Senator Sessions, who represents us well in the Senate, to the other members of the committee. Of course, I am Fred Gray. I live in Tuskegee, Alabama, with offices there and in Montgomery. I appreciate this committee inviting me to appear. I consider it an honor. For over 50 years, I have filed almost every imaginable type civil rights case in Alabama. Many of those cases have resulted in Supreme Court rulings, and many of them precedent-setting cases, in which the court declared unconstitutional certain state and city ordinances, including in the field of registration and reapportionment. As one who has been in the trenches and still is in the trenches, I appear today to attest to the tremendous importance of the reapportionment cases. Those cases decided by the Warren Court, one of which I actually litigated and was my brainchild, the case of Gomillion versus Lightfoot. I am still troubled, extremely troubled by Judge Alito's comments made in his application, notwithstanding the testimony before this committee.
Senate star.
The reapportionment cases decided by the Warren Court made certain that the federal courts had the power to ensure that voting rights were meaningfully protected. These rights had been violated by many of our states since Reconstruction. The cases illuminate the inequities of male apportionment, which deprived African Americans of voting strength across the nation. In my view, there is no more important body of law than that generated in the field of voter registration and in civil and human rights. African Americans in Alabama and other southern states for years, even before Browder versus Gale, which is the case that integrated the buses and which was a unanimous case of the Warren Court, were actively working toward obtaining the right to vote. For example, in my hometown now, Tuskegee, Alabama, the home of Tuskegee University, where Booker T. Washington was its first president, where George Washington Carver made many of his scientific discoveries, and the home of the Tuskegee Airmen. African American in that county filed lawsuits as far back as 1945 in order to obtain the right. After years of litigation, when we were finally able to get approximately 400 African Americans registered for an upcoming municipal election, in 1957, the Alabama legislature passed a law which changed the city limits of the city of Tuskegee from a square to a 26-side figure, excluding all but 3 or 4 African Americans and leaving all the whites in the city. And then the state said, we are not denying you the right to vote. We are simply changing the political boundaries of the city of Tuskegee, and you can't vote now in the city elections because you're no longer there. I thought that was wrong. And so did the Supreme Court. We filed the case of Gamillion versus Lightfoot. That case substantially strengthened the law in securing the right to vote for African Americans. The Gamillion case was the first significant reapportionment case decided by the Warren Court. In a unanimous decision, the court held that the boundary change violated the 15th Amendment. Just as importantly, the court rejected the argument that impairment of voting rights could not be challenged in the face of a state's unrestricted power to realign its political subdivisions. The court stated, when a legislature thus single out a regular, isolated segment of a racial minority for special discriminatory treatment, it violates the 15th Amendment. Apart from all else, these considerations lift the controversy out of the so-called political arena and place it into the conventional sphere of constitutional litigation. There is no question in my mind, but it gave rise, Gamillion versus Lightfoot did, to the other subsequent cases you have heard about, great reapportionment cases, Baker versus Carr, Gray versus Sanders, Reynolds versus Sims. I cannot overstate to this committee the importance of these cases, for they laid the foundation for our democracy. The reapportionment cases enshrine the principle that every citizen has the right to an equal, effective vote rather than to right to simply cast a ballot. State legislators could not dilute the vote of racial minorities by perpetuating unequal voting districts. And most importantly, the reapportionment cases also establish principles for challenging at-large and multi-member electoral systems enacted by many of the southern states after the passage of the Voting Rights Act. When I filed the Gamillion case, we had very few African Americans who were registered to vote and had no legislators. I was one of the first 2 in 1970. Now Alabama has, and across the nation, there are over 9,000 registered, 9,000 appointed and elected officials, and they are there because of the result of the Warren Court's decision in Gamillion, Baker, Gray, Reynolds, and these other cases enacted by legislation since that time. So we have these persons serving with honor and distinguished from city council to the Congress. However, we still need a strong Supreme Court to continue to enforce these laws. I have seen in my home state, as fast as we get one law stricken, they will enact another. Now that we have a proportionate number of African Americans in in the legislature, we want to be sure that we have a strong Supreme Court that won't permit that to be changed. I respectfully submit and suggest that this committee carefully scrutinize Judge Alito's disagreement with these cases. A nominee to the Supreme Court who has a judicial philosophy that's set against the Warren Court and against the reapportionment cases is in effect saying that he would turn the clock back. If this occurs, not only would African Americans lose, the entire nation would lose the great richness of their contributions as we are currently enjoying. In my opinion, a Supreme Court justice with these views would impede instead of protecting the right to vote. In conclusion, I submit that the next appointee to the Supreme Court should favor the protection of voting rights and should strengthen and not weaken the voting right case law as developed by the Warren Court. Thank you very much, Mr. Chairman.
Thank you, Mr. Gray, and thank you for your remarkable service on civil rights and voting rights. Your listing of cases and the listing of clients is enormously impressive, and it's been a great contribution to America.
Thank you very much, Mr. Chairman.
We turn now to Ms. Kate Michelman, who for 18 years up until 2004 was president of the National Abortion and Reproductive Rights Action League, more popularly known as NARAL, Pro-Choice America. Prior to joining NARAL in 1985, she was executive director of Planned Parenthood in Harrisburg, Pennsylvania, where she expanded the range of reproductive health services available in the area. She also trained medical students and residents in child development as clinical assistant professor in the Department of Psychiatry at Pennsylvania State University School of Medicine. And it's worthy of a brief comment that we two Pennsylvanians have had many discussions on this issue at the same health club. It's remarkable
true.
what the health clubs will do.
Miss you.
What's that?
I said we miss you over there.
Well, they don't have a hardball squash court.
Oh. I know that was a
And,
big mistake on their part.
And I had to change health clubs except for the Senate gym where I see Senator Kennedy. We're going to put your time at...
Should we take up on that?
We're going to put your time at 10 minutes, Ms. Michelman,
Oh,
and
thank
we
you.
look forward to your testimony.
Thank you, Senator. And Mr. Chairman and Senator Leahy, who is not here, and members of the committee, it is my pleasure to talk with you today. And I must say I am deeply honored to be sitting next to this great man, Mr. Gray. Certainly for many days we have heard many legal experts and constitutional law theorists, but I think the voices of real people whose lives will be affected by the potential confirmation of Judge Alito have been absent from this discussion. And I am here as one woman among millions whose lives could be indelibly shaped by the confirmation of this judge. In 1969, I was a young stay-at-home mother of 3 little girls, a practicing Catholic who had accepted the church's teachings about birth control and abortion. The notion that abortion might be an issue I would face in my own life never, ever occurred to me until the day my husband suddenly abandoned me and our family. In time, with nothing to live on, we were forced onto welfare. Soon after he left, I discovered I was pregnant. After a very long period of soul-searching, of balancing my moral and religious values about the newly developing life with my responsibility to my 3 young daughters, I decided to have an abortion. I might add, Mr. Chairman, that of the countless women I have encountered throughout my life, not one has made a decision about abortion without first contemplating the gravity of that choice. Not one needed the tutelage or supervision of the state to understand her own ethical values, much less to be reminded to consult them. And every single one of them deserved the respect and protection afforded by Roe v. Wade. Now, because all of this occurred prior to Roe, I was legally prevented from acting privately on my decision. I was compelled to submit to two interrogations before an all-male panel of doctors who probed every aspect of my private life, from my sex life with my husband to whether I was capable of dressing my children. Eventually, they gave me their permission. I was awaiting the procedure when a nurse arrived to tell me that state law imposed yet another humiliating burden. The government required me to obtain my husband's consent. I was forced to leave the hospital, find where he was living, and ask him to give me his permission. Now, this was incredibly humiliating, and an experience that awakened me to a lifetime of activism. And I tell you this story not to get your sympathy. I tell you this story because this nomination poses a real threat that women will once again face the dreadful choice between the degradation of the review board and the danger of the back alley. And this is neither hyperbole nor hype. It is the simple, demonstrable reality of the situation. Predicting how any given judge will decide any given case is a Washington parlor game, in my view, that distracts from the central issue. That issue is whether we any longer will recognize limits on the government's authority to reach into the most intimate areas of our private lives. There is nothing in Judge Alito's lengthy public record to suggest that he recognizes such limits for anyone, and even less so for women. And there is much in his record that indicates, I think clearly and beyond the boundaries of reasonable dispute, that he rejects the idea of privacy, personal privacy, as a fundamental American ideal. A woman's right to choose is a powerful manifestation of privacy, but it is one right among many, and all of them should concern us. There is no sense in Judge Alito's writings or rulings that privacy is a fundamental constitutional right. In his record, not only are individuals often powerless against the prerogatives of the state, individuals are, more often than not, simply absent altogether. In many ways, what Judge Alito has written is less disturbing than what he omits, any sense of how his legal rulings bear on real people whose lives are shaped by his decisions. When he ruled that a Pennsylvania law requiring women to notify their husbands before obtaining an abortion was not, quote, an undue burden, there was no sense that a woman like me ever existed or even mattered. When he wrote that commonly used methods of birth control could be classified as methods of abortion, there was no indication he considered the women who would be forced into unwanted pregnancies. His writings contain ample veneration for the state, but I think place little value on the individuals whom government exists to serve, protect, and respect. I have been involved in many Supreme Court nominations, but frankly none more important than this one, nor as dangerous. For the contrast between Judge Alito and the justice he would replace is quite stark. As the first woman to serve on the court, Justice O'Connor brought a very unique perspective to the law that is evident in her opinions upholding a woman's right to choice, protecting women from discrimination, and defending affirmative action. Quite often, you have talked about this a lot, she has been the decisive vote in 5-4 cases whose balance Judge Alito would now tip the other way. And here, Mr. Chairman, it is important to note that Justice O'Connor is a judicial conservative who has not always fully protected constitutional rights and liberties, but she crafted opinions that retained meaningful protections for rights that other justices sought to deny completely. But the most disturbing difference between these two jurists is not simply the conclusions they reach, but also how they reach them. Justice O'Connor considered each case with careful attention to what the law means and who it affects, for she knows that that is the essence of justice. In Judge Alito's approach to the law, there is neither justice nor regard for women's human dignity. Judge Alito has parried challenges to his record by promising an open mind and a respect for precedent. We must ask whether this assurance offered only now can be allowed to outweigh the totality of this man's record. Millions of American women whose lives, privacy, and dignity have a place in this debate would have to conclude no. Thank you.
Thank you very much, Ms. Michaelman.
Welcome.
Our next witness is Professor Ronald Sullivan, Associate Clinical Professor of Law at Yale. He is a graduate of Morehouse College in 1989 and a law degree from Harvard in 1994. He served for 1 year in Nairobi, Kenya, as a visiting attorney for the Law Society of Kenya, and in that capacity was on a committee charged with drafting a new constitution for Kenya. We very much appreciate your coming in today, Professor Sullivan, and the floor is yours, and the clock will start at 10 minutes.
Thank you very much, Senator Specter and Senator Leahy in his absence, members of the committee. Thank you for inviting me to testify at this very important expression of our democracy. I've been asked to comment on Judge Alito's Fourth Amendment jurisprudence. Two broad themes follow from his record. First, Judge Alito's Fourth Amendment opinions reveal a clear pattern of privileging government power when it comes into conflict with individual liberty. Indeed, in the 17 opinions that the nominee has authored regarding the Fourth Amendment, in his more than 15 years on the bench, Judge Alito has ruled to suppress evidence only once. The second broad theme is that Judge Alito is a skilled legal writer with a sharp analytical mind. Almost none of his opinions appears to be a radical departure from accepted jurisprudential conventions. Rather, his constitutional criminal procedure decisions read together demonstrate a pattern that cannot be ignored. In over 50 constitutional criminal procedure cases that I've reviewed, Judge Alito ruled in the government's favor over 90% of the time. To borrow an old phrase, as the government goes, so goes Judge Alito in the criminal law context. But the point I make here is more than a mere statistical correlation. I want to make a deeper and more substantive point. Judge Alito's tendency to privilege government power in the criminal context represents a failing in his jurisprudence for the following three reasons. Number one, Judge Alito's criminal law corpus demonstrates a judicial philosophy that improperly subordinates privacy, dignity, and autonomy concerns to the interests of the government. Number two, even when the government undeniably violates the Fourth Amendment, Judge Alito employs legal rules to excuse the government for its misbehavior. And number three, Judge Alito shifts from a strict constructionist to an activist jurist at times when the government's interests so dictate. Let me briefly address each of these propositions in turn, and of course I give much greater detail in my written statement. First, privacy and dignity concerns. Grudy against Doe has been discussed all week, and I assure you I shall not be redundant. Let me simply invite the committee to read my comparison of Grudy with another one of his cases, Levito against Lapina. In Grudy, Judge Alito was only able to muster up one clause, not even a full sentence, giving voice to the highest order dignity concerns involved or implicated in the strip search of a 10-year-old girl. Compare this to Levito, a tax evasion case involving the search of a wealthy veterinarian and his spouse who was wearing a nightgown, where Judge Alito devotes 4 entire pages of text to express the, quote, indignity and, quote, stigma concerns associated with the illegal search. In no other, I repeat, no other Fourth Amendment case that Judge Alito authored did he spend even a fraction of the time expressing the dignitary objections that he did in Levito. one is forced to wonder whether Judge Alito has a more robust appreciation for the privacy and dignity concerns of the wealthy, or the class of individuals typically charged with tax evasion or crimes of that sort. Now, in the area of what I've characterized as excusing governmental misbehavior, Judge Alito frequently uses the good faith exception or the qualified immunity doctrine to cure an otherwise illegal search. Indeed, in nearly 1/3 of his Fourth Amendment cases, Judge Alito excuses the government's unconstitutional invasion of our privacy. Now, the insidious effect, the on-the-ground effect of the heavy reliance on the good faith exception or the qualified immunity exception is that the exceptions tend to swallow up the rule. This gives government officials the perverse incentive to knowingly violate the constitutional rights of our citizens because no practical consequences follow. So Judge Alito's rulings will take the following form. There was no substantive violation of the Fourth Amendment, therefore conviction affirmed. Or, yes, there was a substantive violation of the Fourth Amendment, as in the Levito case, and it was a horrible violation. But even though there was a violation, I am going to interpose a qualified immunity defense, and the government is therefore shielded from civil liability. And this form of argument can be seen throughout his jurisprudence. Now to the strict constructionist argument. Judge Alito is praised by many as being a true conservative jurist, a strict constructionist. And that proposition has been almost assumed as I've listened to the hearings this week. But that he is a constructionist is not true all of the time. A review of his entire criminal law jurisprudence demonstrates that Judge Alito shifts his interpretive style when necessary to rule in accord with the government's interests. Two of Judge Alito's opinions illustrate my claim. Sandoval against Reno and U.S. against Lake. In Sandoval, Judge Alito employs a literalistic and plain-meaning construction of the relevant statute to limit the scope of a defendant's rights. There is a very technical habeas issue that I won't go into, but essentially Judge Alito said he cited the captions in the relevant statute in bold letters in all caps twice and said, this is all we have to look at. This answers the question to congressional intent. And that is within the norm of judicial reasoning for a strict constructionist. But he uses this interpretive style to limit the scope of a defendant's right. But in Lake, he shifts his interpretive style and uses a broad, liberal even, statutory construction to augment the scope of government power. More specifically in Lake, Judge Alito found that a car located the functional equivalent of a city block away from its owner and out of its owner's eyesight was nonetheless in the, quote, presence of the owner. To do so, Judge Alito relied on a Ninth Circuit Court of Appeals ruling to articulate a remarkably broad definition of presence. This sort of shifting jurisprudence begins to look like it's result-driven and not restrained in the jurisprudential tradition in which Judge Alito positions himself. We are living in a moment where the executive is making extraordinary claims of authority to conduct investigations of U.S. citizens. The delicate balance between liberty and safety that the framers fought so hard to erect and that their successor generations fought so hard to maintain needs our continued vigilance to sustain. In the United States, perhaps no right is regarded as more sacred, more worthy of vigilant protection than the right of each and every individual to be free from government intrusion without the unquestionable authority of the law. Judge Alito, on my read of his constitutional criminal procedure opinions, shows an inadequate consideration for the important values that underwrite these norms of individual liberty, the very norms upon which this constitutional democracy relies for its sustenance. This committee and this committee's decision on whether to consent to Judge Alito's nomination will have a profound impact on how liberty is realized in the United States. In addition to Judge Alito's constitutional criminal procedure decisions, I have reviewed nearly 415 of Judge Alito's opinions under both the auspices of the Alito Project at Yale, where a number of my colleagues and I reviewed all 415 of his opinions, and under the auspices of the Jamestown Project at Yale, where I serve as a senior fellow. While I haven't studied in detail all 415 of his opinions, and I should say the opinions that he authored, which I found to be most instructive, I find this tendency to be consistent with other areas of the law as well. That said, I would like to thank the committee for the opportunity to share my remarks with you, and I look forward to answering any questions that the committee may have. Thank you.
Thank you very much, Professor Sullivan. We now turn to Professor Amanda Frost, Assistant Professor of Law at American University's Washington College of Law. She is a graduate of Harvard College, 1993, with a bachelor's degree and a law degree from Harvard Law School in 1997. Her areas of specialization include civil procedure and federal courts, the author of several law review articles. As staff attorney for the Public Citizens Litigation Group, she has litigated cases before the United States Supreme Court and federal courts of appeals. She was a consultant for the Shanghai Municipal Government in drafting open government legislation. Thank you for being with us today, Professor Frost, and we'll set the clock at 10 minutes for your testimony.
Thank you. Mr. Chairman, Senator Leahy, and members of the committee, I feel honored to have the opportunity to testify at these important proceedings. My comments today are about reforms that are needed in the procedures and practices that govern recusal of federal judges. Your consideration of Judge Alito may be affected by your views about whether he should have recused himself from certain cases while sitting on the United States Court of Appeals for the Third Circuit. That is why I wanted to discuss with you today the certain problematic recusal practices that too often have led federal judges into situations in which their recusal decisions undermine the public faith in the judiciary. Because the reputation of the judiciary is affected as much by the appearance as the reality of bias, Congress has enacted a statute, 28 U.S.C. Section 455, that provides, quote, "Any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned." By using this language, Congress sought to ensure that even when a judge is certain that he or she could be impartial, that judge must step aside if members of the public might reasonably disagree. In essence, the law requires a judge to recuse even in borderline cases in which the possibility of bias or the appearance of bias is slight. Now, I think this is a good standard, but a key problem with the statute is that it contains no procedural mechanisms to govern the recusal decision. It does not say how the parties are to seek recusal. It does not say how evidence about a judge's potential biases or conflicts are to be shared with the parties. It does not clarify who should make the recusal decision or whether that person should articulate any reasons for making that decision. So, for example, Supreme Court justices recuse themselves in dozens of cases a year, and they almost never explain why they are doing so. When a party files a motion seeking a justice's recusal, which is a rare event and something that most parties would be reluctant to do, there is no formal process through which the entire court considers and decides that motion. Instead, it's sent to the one justice whose impartiality is being questioned, and that justice makes the decision on his or her own, often without explanation. This procedural vacuum has, I believe, been the cause for recurring controversies over judges' failures to recuse, controversies that undermine the very goal of Section 455 to protect the integrity of the judicial branch. So I want to give just a few examples of some of the recusal problems that have occurred over many years. In 1969, Supreme Court nominee Clement Haynsworth failed to be confirmed for that position, in part due to revelations that while sitting on the Fourth Circuit, he had sat on a number of cases in which he had a small financial interest. In 1972, then Associate Justice William Rehnquist, was criticized for sitting and hearing a case that he had commented on publicly while he was in the Department of Justice. In 2004, most of us remember, Justice Scalia made a controversial decision not to recuse himself from a case in which Vice President Cheney was a party, despite having vacation with the Vice President shortly after the Supreme Court had agreed to hear the case. And then most recently, Judge Samuel Alito has been questioned by this committee for his failure to recuse himself from a case in which Vanguard was a party, despite the fact that he owned mutual funds with Vanguard and has stated in his 1990 Judiciary Committee questionnaire that he would recuse himself from all such cases. Now, whatever one's views are about whether the individual judges and justices in these examples should have recused themselves, and I recognize there's differences of opinion on that, but whatever your views are, I think most would agree that the process by which that decision was made did not work to foster public confidence in the judiciary. These problems with recusal law are particularly evident and disturbing at the Supreme Court level. When a district court judge or circuit court judge fails to recuse themselves, that decision may be reviewed by a higher court. As I said, when a Supreme Court justice faces a question of recusal, the justice makes the decision on his or her own, and there is obviously going to be no review of that decision. There's no higher court. Furthermore, the stakes are simply that much higher at the Supreme Court, which hears the most divisive and important cases, and which sets the law for the nation. And finally, the Supreme Court is the public face of the judiciary. And because of this, their recusal practices are more likely to have a negative effect on the public's perception of the judiciary. I propose a series of procedural reforms that could be made either by the justices themselves in a rule or by Congress by amending the recusal laws. First, there should be more transparency. Judges should be required to inform the parties and the public of any information that would be relevant to the recusal question, even if they don't think recusal is required. The parties should be given full information, and the public as well. Second, when judges do decide to recuse themselves, they should at least issue a brief explanation explaining why. That will provide a body of precedent to guide future litigants and judges facing these difficult recusal situations. And third, when a judge does not decide or does not think it's clear that he should recuse himself, that judge should turn that decision over to his colleagues, or at the very least consult his colleagues, rather than make the decision on his own. With these reforms in place, I think we would better protect both the reputation of the judiciary and of the judges who serve the public. Thank you for inviting me to share my views with you today.
Thank you very much, Professor Frost. We now turn to Professor John Flynn, Professor of Law at Northwestern. He has taught professional responsibility and advanced criminal procedure. He served as counsel to Ms. Santi Murari, the plaintiff in the 2002 case where Judge Alito ruled in favor of the Vanguard Mutual Fund. He has his bachelor's degree from Columbia in 1961 and his law degree from Harvard. Thank you for agreeing to be a witness here today, Professor Flynn, and we look forward to your testimony.
Thank you, Mr. Chairman, Senator Healy, members of the committee. I am honored to be before you today. I'd like to make one correction, if you please. It's a common error, but I have taught at Northeastern University, which is in Boston. I am indeed the lawyer who challenged Judge Alito's failure to recuse in the Munger case, the Munger Vanguard case. What I would like to do now is to address 3 points, one of which was particularly addressed by Senator Hatch yesterday in his questioning of John Payton, the ABA Federal Circuit representative. Does the law require Judge Alito to recuse given his investments in Vanguard? Now, my colleague Amanda Frost addressed provision A of the statute, which speaks in general terms and states the general principle based on the appearance. A judge shall recuse if someone could reasonably question the judge's impartiality. Section B, however, is the applicable provision. Section B doesn't state general propositions. It states a specific proposition. Among them, B4 says that a judge shall recuse if the judge has a financial interest in a party to the case. It then goes on in subsection D to define what financial interest means. And it says a financial interest means a financial interest, however small. And then it goes on to list various exceptions. Now, Judge Alito, in his answers filed in the questionnaire which he submitted to this committee, relies on the third exception in subsection D, the one which plainly has nothing whatsoever to do with mutual funds. It has to do with interests, for example, in insurance policies. The one exception that does address mutual funds is the one raised by Senator Hatch. But it says the opposite of what Senator Hatch suggested yesterday. It says that one of the exceptions is that an investment in a mutual fund shall not be regarded as a financial interest in the securities held in the fund's portfolio. Now, that's an obvious proposition. It has nothing whatsoever to do with simply saying that investment mutual funds doesn't qualify as an interest, as a financial interest within the meaning of subsection B, because if it did, Congress would simply have defined what it would simply have said in the exceptions that financial interest doesn't include an investment in a mutual fund. That's what the statute says. Now, the statute goes back to 1974. It would be astonishing if there weren't interpretations, case law of the statute. There are lots of interpretations. The Second Circuit in 2002, that is the year before Judge Alito wrote the December 10th letter to Judge Sirica saying, after I received the November 2003 motion that I should have recused myself, I reviewed the law, and having reviewed the law, I concluded that the statute doesn't require me to recuse. But nevertheless, I'm going to do that so that you can appoint a panel to consider the pending motion. He did not recuse from the case. So, more important detail than might otherwise appear. Now, in his statement to this committee, his reliance on the third exception for insurance policies is unexplainable. It is incoherent. It has nothing whatsoever to do with mutual funds. The first exception, with due respect to Senator Hatch, says the opposite of what the senator suggested yesterday. It says mutual funds do count as financial interests. They simply do not include investments that the fund makes in the securities, that is, the securities which are listed in the fund's portfolio. Now, I, like everyone else, have been enormously impressed by all of the testimony, particularly his colleagues and everyone who's worked with Judge Alito, that he is a brilliant man, that he studies the law very carefully, that he takes pays particular attention to the arguments presented to him because he's a fair-minded man. Now, at the time that he wrote this letter, he had the benefit of the motion, which included everything that I've just told you, including the case law and the analysis, and a lot more. It is inconceivable to me that he could have made the statement that he made in his letter to Judge Sirica and in his questionnaire to this committee. I will now move on to a second point. The second point is part of what he testified to. He said that he is, and I think this was in response to a question by Senator Kennedy, and I am one of those judges that you described who take recusals very, very seriously. Is that a credible statement? He also says that it never crossed his mind that there was a recusal issue when he looked at the Vanguard case. The name Vanguard is plastered all over the documents. We're talking about literally dozens and maybe hundreds of references to Vanguard, including in the opinion that he himself authored. He made a pledge to this committee in 1990, which I assume he did after reading and understanding what the 1974 recusal statute said. He continued to invest in Vanguard over the years and watched his investments grow into the hundreds of thousands of dollars. I've heard estimates that run way beyond the $370,000 which have been mentioned here. And while he was sitting on the appeal in the Vanguard case, he continued to make investments, both before and after the opinion. Now, I would like now to move to a third point, which I consider to be perhaps most important, in a sense. Maybe not most important, but just as important. I spent 40 years of my professional life representing the little guy. My client, Ms. Maharaj, exemplifies the little guy. She has nothing, not one penny. All she had was the IRA, which by law passed to her at the death of her husband in 1996. Now, that IRA is supposed to be sacrosanct. The Supreme Court has held in a trilogy beginning with Guidry in the 80s, Patterson in 92, and most recently Rousey in 2005, that creditors can't reach IRAs. Now, just as has been suggested with respect to how the Roe decision may be undone through small creative exceptions to that rule, likewise here, what the judge did, and I'm confident that he did read the record and that he understood all too well what was at stake, was go out of his way on the most dubious of legal principles to rely on his supposed decision of the Massachusetts court, which in fact is on appeal. I argued the appeal in October. There is no decision yet. We don't know how the Massachusetts court will decide, but all of the law which I set out in my motion makes it clear that he had no business relying on that Massachusetts decision. What that means is that with respect to IRAs only, never mind the other forms of retirement savings, 40+ million Americans with their savings in IRAs, with more than $2.3 trillion in those IRAs, could see the security in what they thought were sacrosanct savings beyond the reach of any creditors, no qualification, as the Patterson court said in 92, all of a sudden threatened the same way that the employees of IBM suddenly woke up to discover that their pensions were pretty much smoke and mirrors. Thank you very much, members of the committee. I realize that I spoke with some passion. I had promised myself to be calm and collected, but I confess that unless, but for the fact that President Bush nominated Judge Alito, no one would ever have heard of Ms. Maharaj or the Vanguard case and Judge Alito's role in it. Thank you.
Thank you very much, Professor Flynn. Mr. Gray, beginning my 5 minutes of questioning with the issue of voting rights, which you have testified about so eloquently, are you at all comforted by Judge Alito's statement that the principle of one person, one vote is firmly embedded in the law of the land, and he will follow that?
Well, I'm still troubled by the fact. I'm glad to hear that. And if what that means is that if he is confirmed, he will be the type of justice protecting civil rights and human rights that Hugo Black did when he was on the court, then I would be happy to have him serve. But I don't remember, and I think the first time I recall that he made this statement is after it was raised in these hearings. I would think if he was sincere about it, realizing what he had said in 1985, that he would have disclosed the fact that I said that then, But my position now is entirely different and would have been rather candid, upright before the matter was raised. I'm troubled that we would even have a nominee who would have to explain this, because if these rights are so embedded, then there should never have been any statement the way it was in the first place.
Ms. Michelman, on the Roe issue, which is a matter of enormous importance, I started my questioning of Judge Alito with that subject, as I did with Chief Justice Roberts. And we've had the examples of Justice O'Connor, who was against abortion rights before she came to the court, and Justice Kennedy against abortion rights, and a lot of worry about Justice Souter. And you have the political process where the judicial appointments are part of the process. And you heard Judge Alito talk about the precedents and the culture of the country and being embedded and a living document, which is very different from what some others have testified to in recent times. You watch this situation very closely, and you've noted who some of the other prospective nominees are, at least reported. If Judge Alito is rejected, what do you think the prospects are of getting a nominee whom you'd like better?
Well, Senator, it is true that the president won the election and he has the right to nominate justices who share his values and his views. He made it very clear that his model justices were Scalia and Thomas, whose views about women's constitutional legal rights, including the right to choose, are a danger to American women and to their lives and their health and their dignity. So he has that right, but you share a co-equal responsibility, and the American public, the individuals in this nation, have only a voice in this process through you. And I would answer you by saying that I think every nominee has to be evaluated on his or her merits, on his or her record, on his or her views, judicial and philosophical views included. And we have to take one at a time. And if that nominee's record is clearly a danger to the constitutional and fundamental rights of the American people, then I think that nominee should be defeated and we'll take on the next one. But I think the president has made his case on this nomination. I think Judge Alito's record, and if you look at the totality of his record, his service in the Justice Department, his service on the court, it is very clear that he will move the court in a very different and dangerous direction for women's legal rights. And
I want to ask you
Anyway.
one more question, and my time is almost up. You have commented about the other issues, philosophical. You haven't enumerated them, but we've been over executive, legislative power. We've been over congressional power, affirmative action, many items. Do you think that a nominee ought to be rejected on the basis of a single issue?
I don't consider the right to privacy, personal privacy, the right to dignity and autonomy and control over one's life as a single issue. I do think it is profound and will have enormously important implications for women, for men, for families in this nation. And I do indeed think it is so serious and profound that he should be rejected on those grounds, even if there were no others, and I would subscribe there are other grounds.
Well, thank you very much for
welcome.
your testimony, Ms. Michelman, and for your service. You have been in the forefront of this issue for a long time, and I know how deeply you feel about it. And thank you for sharing with us your personal experiences. They're not easy to testify about. Senator Leahy?
I would concur with that.
Thank you, Senator.
I thought of that prior to your testimony, reading the article about you yesterday in the Post. A a story I was familiar with. And you know, one of the reasons I came back, I'm at a friend's memorial service, and we'll return to that right after my
Thank you.
questioning. But you're absolutely right that there's an awesome responsibility in the Senate in the choice. First, with the 18 of us here, who are the only 18 people in America who got to question Judge Alito. If you don't count the first vetting that he had by Vice President Cheney, Karl Rove, and Scooter Libby a day or two before he was nominated by the president. That, of course, we're not privy to what was said or what assurances were made, nor was he about to share that with us. Mr. Gray, I'm glad you are here. You spent a lifetime, a very distinguished lifetime, in fighting for those denied the right to equal protection and equal dignity. I know that after you graduated law school, you immediately went to work defending two icons of America, Rosa Parks, Dr. Martin Luther King, Jr., Montgomery bus boycott. And we've heard Judge Alito say that one of the things that motivated him was his objection to Baker versus Carr, the reapportionment case. We heard Justice Frankfurter, who delivered a scathing dissent in that. And we know the position of the second Justice Harlan, whom Judge Alito admires, who feels very strongly that Baker was wrong. How important was it that the Supreme Court didn't follow these attitudes, didn't follow Justice Harlan's lead, instead intervened in the 1960s to correct massive disparities in the size of voting districts, the underrepresentation of voters from urban areas, removals of poll taxes and other barriers to minorities to vote? What is the difference it makes in America today that the dissenters did not win?
The difference is, then, prior to these decisions, and even prior to Brown versus Board of Education, and prior to Vermillion v. Lightfoot and Browder versus Gale, the case that desegregated the buses, we had very few African Americans and other minorities registered. We had little or no African Americans to public office. For example, in my state, in 1957, we had none. Now, my state has approximately the same number of persons in our state legislature. It mirrors the population. We now have thousands of African Americans and other minorities who are holding public office, and an additional 1,000 that those public office holders have appointed to elected office.
When you first started this fight, did you ever believe you'd see an African-American mayor, an African-American sheriff, and
No,
some
sir.
of those guys?
No, sir. And the
Right.
first one since Reconstruction was Lucius Amerson in my county. I
Right.
got him elected, but I couldn't get elected to the state legislature in
That's why
1966.
I raised that. You anticipated what I was raising. And Ms. Michelman, you know about the job application of Judge Alito's to the Meese Justice Department. He said he personally believes very strongly the Constitution does not protect right to abortion. In your reading of Judge Alito's writings, but especially your observation of the past few days of these hearings, have you seen or heard anything to reassure you that Judge Alito's personal beliefs about constitutional privacy will not affect his issues as a judge?
No, I haven't. In fact, I don't think there's, again, if you go back to the memo you're referencing, the work he did in the Justice Department and his record on the court, his decisions on the court, I think reveal very clearly that he does not believe deeply in a fundamental right of privacy and applies that belief that the Constitution protects that fundamental right of privacy to individuals. So no, I'm not. I am deeply concerned that Judge Alito not only was proud and discussed very openly how proud he was to be a part of an administration that repeatedly sought the court to overrule Roe and overrule other privacy cases, but that he actually laid out a strategy for the administration to pursue the overruling of Roe in an incremental strategy, to pursue taking away the right of women to decide for themselves and to keep the government out of these very private decisions. He laid out a strategy that you could keep Roe in place as a shell, not overturn it directly, but incrementally dismantle those rights. And the states, by the way, the anti-choice movement in this country has pursued that strategy very effectively, and there are now hundreds of laws that really burden women, both financially and emotionally, when they're trying to make responsible choices. I have no confidence at all that Judge Alito, when faced with the question of whether women should decide or whether the government, state and federal, has the right to interfere in these intimate decisions that women make, that he will come down on the side of the government.
My time is up. I just want to thank all
Thank you.
5 of you for being here. I know that it's not easy to come and very publicly oppose somebody who has the backing of the President of the United States and the backing of so many powerful senators to be on the U.S. Supreme Court. But it goes to the tradition of speaking truth to power, and I thank you all.
Thank you, Senator Leahy. Senator Hatch.
I think I'll reserve my time, Mr. Chairman.
Senator Kennedy.
Thank you. 5 minutes, number of areas to cover. First, thank all of you for being here. And Dr. Gray, in the application, the 1985 application, and where the nominee points out, in college I developed the interest in constitutional, in large part, disagreements with the Warren Court decision, particularly in the areas criminal procedure, establishment clause, and reapportionment. Just very, very quickly, how important in terms of having our nation a fairer, more just nation were those Warren Court decisions on reapportionment? And what would this country, just quickly, what would this country look like if they hadn't made those judgments and decisions? Would we be a different nation?
We would be a different nation, and it would all appear to be whites, and no persons of color would have very little, if any, involvement in it.
Professor Sullivan, I want to ask you about the impact of Judge Alito on average Americans. This is something we've heard from the power structures around here. I want to hear what your impact that you believe his service on the court for average Americans. And I want you to clarify that not all Fourth Amendment cases are criminal cases. They're civil cases, too. Could you comment about
Yes,
that?
That's correct.
The idea is that sometimes innocent people are caught up on these police searches and bring Fourth Amendment charges.
Yes. In Grudy, for example, which we've talked about a lot, it was a civil damages case. The Congress has provided a remedy for citizens when their rights have been violated, their constitutional rights. In this case, search and seizure rights. Let me say that the Warren Court, in answer to your question, set forth a jurisprudence with respect to the Fourth, Fifth, and Sixth Amendment that, in effect, limited the scope of police power vis-a-vis the average citizen. That there are some rights deeply enshrined in the Constitution that we all have, from the highest and most powerful to the average Joe. And that's what the Fourth, Fifth, and Sixth Amendment protect. My read of Judge Alito's jurisprudence in this area is that he weakens the protection. He's very deferential to institutions and would allow law enforcement practices to expand in a way that I suggest to you would have a negative and detrimental impact on the non-powerful in our country.
Professor Flynn, just on this issue of recusal, is it your understanding that under the existing code of conduct for the U.S. judges that Judge Alito should have complied, should have recused himself, and should have established on his letter of recusal or on the system Vanguard, and that he failed to do so with his interpretation of the ethic?
Absolutely, Senator. But in addition to the code of judicial conduct that is frequently understood in terms of ethical rules, the statute enacted by Congress in 1974 trumps whatever else may be adopted, and it's unmistakably clear that he had an obligation to recuse.
Thank you. Michael, I want to, first of all, thank you. There was a splendid performance on Meet the Press a week ago.
Thank you,
And
Senator.
I think in that, in response to the questions, just to pick up on the chairman's thought about where you talked about the dignity of women. You touched on it here now. I'd just like you to use up whatever time I have in talking about what you think the implications would be by this nominee, just on women's issues just generally. I think you've spoken very, very eloquently on the choice issue. Obviously, refer to that if you would, too. But I'm very, very interested in this broad view of yours about both the dignity of women, women in the family, women in our society, women, the role that they're playing, and a bit about what kind of country would be if we didn't have justices that protected that.
Right.
And what kind of country we can become if they do.
Well, thank you,
Please.
Senator, also for your generous comment about my Meet the Press performance. We should not forget that women have had a long and hard journey to full equality in this nation. It's only been 84 years since we've had the right to vote. So it's been a long and difficult journey, and one that has taken great effort, and both as a political movement, but also through the law, to have recognized that we could vote, we could own property, we could get charge accounts, which I was denied the right to have a charge account because I wasn't married in 1969. It was shocking. So there has been a very long and arduous journey, and women's equality and full capacity to be partners, equal partners with men in the socio-economic, political life of this nation is dependent on our right to determine the course of our lives, our right to education, our right to employment, our right to equal pay. All of these things are determined by our right to control our lives. And we absolutely need a legal system that recognizes, respects women's dignity and autonomy, including our right to determine when to become mothers and under what circumstances, and even whether. And it's hard to find the words to adequately express how important that is.
Excellent. Time is up. Thank you, Mr. Chairman.
Thank you, Senator Kennedy. Without objection, there will be placed on the record a large group of letters relevant to the issue. And I want to remind everybody on the committee that under committee practices, that as with the proceeding on Chief Justice Roberts, all questions must be submitted within 24 hours of the close of the hearing, which will be a little later today, perhaps even shortly. Senator Hatch.
Let me just greet all of you and thank you for being here, Dr. Gray. I have tremendous respect for you. You've led a lot of fights in this country under very, very trying circumstances. Having been born on the other side of the street myself, I understand a little bit about how tough that might be from time to time, but I'm sure not nearly as much as you understand it.
Thank you, Senator.
Ms. Michelman, it's always nice to see you.
Good to see you, too.
And as you know, I have respect for other points of view as well.
Oh.
Mr. Sullivan, nice to get acquainted with you. Ms. Frost, with you. Mr. Flynn, I have to say I disagree with you, as do almost every ethics expert I know, including the American Bar Association, but I appreciate your advocacy for your client. That's always appreciated by me, and respect you for it. But I just wanted to greet all of you and let you know that we appreciate you coming.
Thank you.
Thank you, Senator Hatch. Senator Sessions.
Mr. Gray, it's a delight to have you here. You're certainly one of Alabama's most distinguished citizens. Mr. Chairman, Mr. Gray just completed 10 years president of the Alabama Bar Association and traveled the state extensively and talked on these subjects, and I think reminded people a lot about just what our situation has been and how far we've come and things that we still need to do. So Mr. Gray is an extraordinary leader capable of holding any high office in this country, and it's a pleasure to get to know him. I've read with great interest his book, Bus Ride to Justice. He talks about that first bus boycott in the 50s with Rosa Parks and Martin Luther King, and the tension and the work and the enthusiasm and the courage that was shown at that time. It's really remarkable, and it's important for us to remember it. We've got a lot of things to do, but Mr. Gray, I thank you for your service.
Thank you very much, Senator, and I even talk about the judgeship which was not to be in that book, too.
Well, we've both been there, haven't we?
Yes, sir. Thank you.
And we may have a little more jaundiced eye than some around here about this process. When you came out of college, I noticed in your book you mentioned several times you had a commitment in the 50s, destroying everything segregated I could find.
That was the motivating fact, Senator, as to why I became a lawyer. And I wish this nominee had that kind of commitment. If so, I would not feel uncomfortable and would not be troubled.
Gamillion versus Lightfoot was, I mean, you had the Vivian Malone case at the University of Alabama. You were involved in that. The syphilis study at Tuskegee, the Gamillion versus Lightfoot, and of course Rosa Parks case. But on Gamillion, you made an argument that I think at first appeared not to be. I mean, Colegrove versus Green was a Supreme Court case that seemed to stand squarely in your way. In fact, you lost it in earlier rounds of the court. But you had a vision that that this gerrymander of that city was directly driven to deny people the right to vote. And that was your idea and your concept. Briefly just share that.
Yes, sir. That is exactly the thing. And I illustrated it by having a map drawn to scale of the old city limits and the new city limits, showing where the blacks were excluded and they go all the way in to include whites. So, and I think that case, no question, set the precedent for these other cases. If Reynolds versus Sims had been first, I don't think we would have won. But with Gamillion, which shows an extreme situation, but the purpose of the state in all of these cases was the same, and that was to avoid minorities from voting. Now, I'm glad we've passed that, but we still have, even in Alabama, major cases. The higher education case, the Knight case is still pending. We still have cases in Lee v. Macon that I filed in 63 elementary school cases where there are no terminal degrees in, and now my sons are handling those cases. And we still have a teacher testing case in Alabama that is still pending. So we need to have a strong Supreme Court if we're going to continue to make progress.
I would point out a couple of things. First, it took a reversal of precedent to make this happen, and so sometimes bad precedent ought not to be kept on the books. We've been talking about precedent and stare decisis an awful lot here, and I wanted to mention that. And I would just say, Mr. Gray, I think as Judge Alito has explained it, his father was a nonpartisan clerk for the New Jersey legislature. They were trying to redistrict the legislature, and the court was ignoring classical geographical or political boundaries, counties, and that kind of thing. And that's where his frustration came, not with the concept which he has affirmed clearly here of one man, one vote.
I want to thank you, Senator, and I want to publicly thank you for doing what you have done in helping the Tuskegee Human and Civil Rights Multicultural Center, which is designed to preserve some of this rich history in our part of the state, and I want to thank you for it.
And we can thank Chairman Specter for helping us some on that.
Thank you very much.
Thank you, Mr.
You weren't going to conclude Senator Sessions without saying why you can thank Senator Specter.
For helping us with the Tuskegee Human and Civil Rights Center. Thank you,
you.
sir.
Senator Coburn.
I will,
Always been accommodating.
Senator, I will defer. There's obviously a very distinguished panel before us, each leader in their own way, respected for their advocacy and their heart and their desire to make our country better. And the fact that you would come here today and put forward your views lends great credibility to the process and places more responsibility on us to hear every point of view as we make a consideration on this nominee, and I thank you for coming.
Thank you.
Feel back.
Thank you very much, Senator Coburn. Thank you, Mr. Gray, Ms. Michaelman, Professor Sullivan, Professor Frost, Professor Flynn. And we will take a 5-minute recess while the next and final panel comes forward.
Thank you.
The Judiciary Committee is taking a 5-minute break. That is Bill Reynolds, the Chief of Staff for Senator Arlen Specter, the chairman of the committee. And coming up, the last panel of witnesses, which will feature a couple of Democratic representatives, Debbie Wasserman Schultz of New York, and Florida, rather, and Charlie Gonzalez of Texas. A 5-minute recess here ahead of the last panel of witnesses on this 5th and last day of hearings for Judge Samuel Alito. Once the hearings wrap up today, here's what we have ahead. We're going to show you some highlights of some of the back and forth today. We're also going to take some of your phone calls and see your impressions over the past 5 days. We expect to talk to a Capitol Hill reporter who's been covering the hearings this week, and a look ahead to what's coming up next week as far as the schedule. We've heard that Senator Specter may speak to reporters once the hearings are all wrapped up. And we do want to remind you also that you can see today's hearing again tonight at 8 o'clock on C-SPAN. Over the weekend,